thing. Apparently I left it in the other room. Ready
You're on.
anytime you are, Jace.
You're on the record now.
Okay, good morning. I'm going to call to order the Nevada Transportation Authority General Session hearing for November the 6th, 2025. It is the appointed time. In fact, we're about a minute late. We'll start with a roll call.
Morning, Chairman Hartung. I'm
Here.
going to call you first. Chairman Hart,
Present.
Commissioner Louis Zolka,
Here.
Commissioner Adam Teddy,
Here.
Applications Manager Liz Babcock,
Here.
Financial Analyst Garrett Hammock,
Here.
Deputy Attorney General Radhika,
Here.
Administrative Attorney Yoni Wilburn,
Present.
Chief of Enforcement.
Here.
And then myself, Deputy Commissioner Todd Park. I'm here.
Okay. Looks like we not only have a quorum, but everyone is here. That will take us to item number 3, Pledge of Allegiance. I have one Mr. Michael Bombach from the Tow Association in the room with me, and I'm going to ask him to lead us in the pledge, if you would, sir.
I certainly will. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Mr. Bombach.
Thank you.
My understanding is that you are ex-military as well.
I am Navy for 6 years.
Thank you for your service, sir. Thank you so much. Okay, that takes us to item number 4, public comment. I don't have any cards of anyone wishing to speak. So, Mr. Park, I'm going to let you run us through public comment. Public comment is welcome. We're limiting it to 3 minutes. This public comment period is items both on or off the commission's agenda. So with that, go ahead, Mr. Park. Do we have anyone in Las Vegas wishing to speak?
No, we do not.
Nobody raising their hands?
No hands are raised online.
Okay, perfect. Thank you so much. All right, I'm going to close item number 4, public comment. Let's go to item number 5, approval of the agenda. Before we go to that, Ms. Babcock, are there any additions or deletions or changes?
The only item that I have for this agenda is item 103. There was a typographical error on the draft order that was in the binders. However, that has been corrected for signature.
Okay. And I do not believe that that's substantive enough to remove it from the agenda. Commissioners, any questions? If not, I'll entertain a motion on item number 5, approval of the agenda.
So moved, Chair. Second.
I have a motion by Teddy, second by Zoka. Let me just make sure, is there any public comment on approving the agenda? Seeing none, all those in favor, please signify by saying aye.
Aye. Aye.
Motion carries unanimously. That takes us to item number 6, approval of the minutes. I'll start with you, commissioners. Any amendments or emendations to those minutes necessary that is for October the 9th?
None for me, Chair. None for me, Chair.
Do we have any public comment on the minutes from October the 9th?
No hands are raised.
Seeing none, looking for a motion.
Mr. Chairman, I move that we approve the minutes of the October 9th meeting.
I'll second that, Chair.
Have a motion by Zoka, second by Teddy. All those in favor, please signify by saying aye.
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 Motion carries unanimously. Same routine. Commissioners, any emendation or changes to the minutes on October the 10th? That is 2025.
None for me, Chair.
None for me, Chair.
Is there any public comment on item number 7? That's the approval of the minutes for October 10th.
No hands are raised, Chair.
I will close public comment, bring it back to the board. Commissioners looking for a motion.
I'll make that motion, Chair. Approve
A
the,
motion by. Okay, do
Second.
I have a second? Okay, perfect. Sorry for the delay. Have a motion by Teddy, second by Zoka. All those in favor, please signify by saying aye.
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 Motion carries unanimously. That takes us now to briefings from commissioners. Commissioners, I'll start with this. It is now coming on fall in Northern Nevada. It's a beautiful time to be here. I'm sad that you're not here with me. I know you have F1 coming up. I'll let one of you speak on that. But for the most part, other than, and I don't know, maybe one of you can speak on, maybe when we get to the deputy commissioner, we can speak on if there's any change in traffic at the airport due to the federal issues that they're having with the budget. But we don't see any changes in traffic that I'm aware of up here. Other than that, I have nothing else. Commissioners.
For me, I would just like to take a second to thank enforcement and their work to try to address the situation with the illegal carriers in town. As we all know, there was an influx of illegal carriers, and they are working diligently to try and address that issue, which hopefully pushes locals and visitors to our licensed transportation providers. So I just wanted to applaud their efforts. Thank you.
Very nice. Thank you so much. Mr. Zoka.
Thank you, Mr. Chairman. I would like to echo those comments, thanking our enforcement for their diligent work and continue to enforce the violations of NRS 706, 476, and the other related statutes. I think it's one of the biggest concerns I have as a commissioner is the illegal operators that are out there and are placing the public at risk. I also want to thank staff for the tireless work they've done on this agenda. We have a lot of items. They have done a tremendous amount of work. So thank you so much. Those are my comments, Mr. Chairman.
Thank you, Mr. Zoka. And yeah, I couldn't agree more. And one of the things that I'd like to have, and Mr. Park, you and I have talked about this, I'd like to have updates, periodic updates, maybe every other session, or if he feels he can do it every session, that'd be fine too, from our enforcement chief, not for question and answer, but just general updates to sort of give us some thoughts on what's going on. Is there anything else, commissioners?
None for me, Chair.
None for me, Chair.
Okay, thank you so much. We will close item number 8. We'll take it to item number 9. Mr. Park, Deputy Commissioner Park.
Thank you, Chairman. I am going to yield a little bit of time to the enforcement chief, just to give a little bit of an update. I know he's been working tirelessly. He was out late last night. The enforcement staff did an excellent job last night on illegal transportation, but I'll let him say a few words about it.
Wonderful. Mr. Chief, would you sit over next to Miss Kuhnel? Much better. Thank you. This way I can see you. Otherwise, I get the back of your head.
Want to sit right there?
Sure. Please, I'd love, I have no problem with it. Yeah, absolutely. Would you like a gavel? Would you like a gavel, Mr. Del Padre?
I have brought my own.
Tell them the gavel.
You have your own? Well done, sir. You come prepared. I like that.
All right, so Dominic Del Padre for the record. Okay. Our numbers for October dipped a little bit, mostly because of the really long agenda. That kind of took a whole week out of our sales there. But for November, we're already tracking numbers to be back at least up at September numbers. It has been difficult to get out and make any improvements on the new techniques that we want to try. But it's going to happen before the end of the month. So that. Question?
Perfect. I'm not gonna, so don't take offense to this, Chief. I'm not gonna allow any back and forth because I don't want the public to think this is just an update from you. I want to thank you for that update and look forward to seeing the results of future endeavors. Thank you so much. And Jace, in the future, and Liz, let's put a slot for the chief, whether he has an update or not, that's okay. But as long as we have a slot for him, that'll be good on the agenda.
Will do.
Thank you. And Jace, also, can you mute when we get participants joining? Because it interrupts what I hear. I don't know whether you guys can hear it also. Can we mute that?
Working on that.
Thank you so much. All right, that takes us to item number 10, report of legal counsel. Ms. Cannell, welcome.
Chairman, do you mind if I say a few comments? I know I yielded some of my
Oh, I
time.
apologize. I'm sorry. I thought you yielded your time and you were done. No, please, the floor is still yours, Mr. Park. I apologize. Thank you. Go ahead.
Him to go first because I knew he'd look better than I would. So I echo the commissioner's thoughts on the staff. We're still continuing to come out of the hack of the state system. We're trying to catch up, but the staff has been working so hard to get that taken care of. I have also received a couple of compliments on staff members that I'd like to publicly recognize. Yesterday, one of the owners of Casa Limousine stopped by and spoke with Chief Maine, and they were really enjoyed working with one of our compliance audit investigators, Marta Acevedo. They mentioned that Marta made her feel very comfortable throughout the process, and she really liked working with her. She also commented on Marta's kindness, understanding, and the helpful support she provided during the application process. And the other one was a comment that was sent to our NTA inbox. I'll read it. Good morning and greetings to the NTA team. I want to let you know that I have been on a long journey with you in a process where to finish it, you need a person like Chris Gretton, who has been with me from the beginning and at all times helping and supporting me. She is very professional in her work, very serious, but at the same time, she transmits a lot of energy and desire to keep going. Thanks to Chris for her professional help. I have my own business and I can start a new stage in my life. Also, I want to talk about Inspector Kim, an excellent person, very professional. He gave me very good advice for my business and his work was very satisfactory for me. And I want to say, I know that this process, a lot of the things that we do for regulation is tedious, is long. And I'm glad that we have a staff that's willing to take their time out of their day and go the extra mile. And I just thought those two comments were appropriate to bring up for this meeting. So that's all I've got, Chair.
Thank you so much, Mr. Park. And and I'm going to add a couple of things to that. Rarely do we see that, and I love to hear these kinds of comments about our staff, but I know that all of our staff works diligently. They work very, very hard to try to help people through the process. And the sad part is you don't hear about all of those endeavors typically. Every once in a while you get these wonderful letters and they're certainly a blessing, but most of the time they only reach out when they feel like they've had a problem and they want to point out issues and as they should, appropriately so. But it is refreshing to hear some of these comments, and I know all staff, whether it's compliance or enforcement in both Reno and in Las Vegas. They work diligently to try to just make sure that it's as smooth as possible. Nobody's going to deny that the process is arduous. Miss Babcock and I are working on a document right now to try to help people navigate some of this stuff. And all I will say is hopefully it'll be in use soon, or if we have to put it in front of you guys, I'm happy to do that. And then we'll just start going systematically through all of our documents to make sure that they're easy to read and in plain language. So with that, I'm going to close that section and I'm going to take us to item number 10. If there's nothing else, commissioners, that I need to go back on, to report of legal counsel.
Good morning, Chairman and Commissioners. We don't have too many updates since our last update. I believe Life Sciences, our briefings are due on Monday. We'll have a brand new update next year, during the next agenda, but for now, we are good. Nothing new to report.
I have a question. Did Mr. Jenkins file an appeal on that?
We haven't heard anything yet.
Okay, thank you.
Thank you, Mr. Zoka. Thank you, Ms. Cannell. Ms. Wilburn, anything from you?
Nothing from me, Chair.
Okay, thank you so much. All right, if there's nothing from anybody else where I need to back up or anybody else wants to make any comments, I'm going to move on and take us to our administrative citations and impounds. That's items 11 through 96. So,
Chairman?
yes, ma'am.
I apologize. Administrative Attorney O'Neill Wilburn. I do have Mr. Carson here who would like to have 52 pulled from the block.
Perfect. I was going to ask if there was anyone here. So item number 52 will be heard separately.
Mr. Chairman, I also see on the sign-in sheet that somebody signed in for item number 46. Since it's part of the citation docket, I would think that we might want to hold that as well, just in case.
So let's ask. So, and he's in Las Vegas, and I can't read his name. Is it?
Jose
Arias?
Are you just here to observe or, okay, do you want to speak related to the matter? Are you just here because you got a letter?
We're here because we got the letter. Commissioner, give me a minute. Sure. You can continue going. I'll just speak with that briefly. Chairman, you can continue going.
Well, if I got to pull items, I want to know before I do a block vote.
Yeah, give Yonit just a minute. She's gonna work it out.
Okay. And we will pull item number 52, which will give me an opportunity to pull it up, by the way.
Item number 46 does not need to be pulled from the block, Chairman.
Okay, perfect. Thank you so much, Ms. Wilburn. So, Commissioners, I need a motion for items number 11 through 96, excluding item 52, which we will pull from the block.
Mr. Chairman, this is Louis Zoka. At the time, in the past, I was the counsel for enforcement. So a lot of these items were actually enforcement matters in which I participated. So based on that, I'm going to recuse myself from the vote encompassing the block vote from items 11 through 96. Thank you.
Okay, very good. No, and I was gonna, I should have jumped on that, and I apologize. So actually, Mr. Teddy, before we entertain a motion on this, let me make sure, is there any public comment on items number 11 through 96, excluding item number 52? Is there any public comment? I don't see anybody with their hands raised, nobody in Las Vegas. I have no one here in Reno. So I'm going to close public comment. I'm going to bring it back to the board. I'll make a motion to approve items number 11 through 96, excluding item number 52.
That was you made the motion to approve that?
Yes.
I'll second that, Chair.
Okay, so I have a motion by Hartung, second by Teddy. We have asked for public comment. All those and Zoka has recused for reasons of conflict in the past. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. All right, that takes us back to item number 52. Mr. Carson, are you available to come up and talk to us?
Thank you, Mr. Chair. Can you hear me?
I can. Thank you. Welcome, sir.
Good. For the record, my name is Brent Carson. I'm here as the attorney for the respondent on item 52.
Sorry, Mr. Chairman, I apologize. This is item number 52 was a matter in which Ms. Cannell was counsel to the enforcement. But I do remember talking to Mr. Carson about this. Maybe I'm incorrect. So Mr. Carson, would you be okay with me participating in this particular matter, item number 52?
Yeah, there's,
Would
I
you
don't
waive-
have no problem with you.
Okay, thank you. So you waive my participation as a member of this body.
Yes.
He
you
waived
do.
her recusal.
All right, thank you.
No,
Thank you. Go
This
ahead,
was-
Ms. Carson.
for the record, I did speak to him back at the very beginning and asked if I could speak to, I think at that time, Chief of Enforcement, Don Foster. And he said, yeah, you can go ahead and communicate with his client.
Okay.
That's what I remember.
Okay.
Okay, so listen, we all know what this one is. This one is something that we've gone over and over again. It's the language on one hand, state of Nevada on the other. This was a little bit unique in that the CPCN did not have that language, but the approved tariff did. So I think it was back in January when the chair put this on for like, what does this mean and which one is, controlling and stuff like that. I don't know if you guys have had an opportunity to review all the stuff that was in the file, whether it was the briefs that were submitted to then Commissioner Don Gibbons, but it's always been my position on behalf of my client is that it was the CPCN that was a mistake, not the tariff that was the mistake. I took my shot, which I'm entitled to because we got cited, and the commissioner ruled against us at that point in time. I'm definitely not in support of that ruling, but I understand that is her ruling, so that's why we're here for today. So like I said, we always told you guys and up front is that it was the CPCNs, and if we were found, in violation and you guys ruled that the other way off us, we would file a motion or a petition or an application for expansion of authority, which was done yesterday, actually. So we did move forward with correcting the CPCN. In the meantime, our tariff will be corrected as soon as this order is adopted by the commissioners. But just for the sake of letting you guys know, we did go through, we did go through and did a application for expansion of authority. That being said, this morning, I had a chance to review the order that was in there, and I did speak with Administrative Attorney Yoni Wilburn on regards to paragraph 3 of the order, where there said that there was an amount held in abeyance for 2 years, provided no further violations of NRS or NAC 706. Believe that is incorrect. It was just for the abeyance was held for any violations of NAC 706.360.
Administrative Attorney Yoni Wilburn, that is correct, Chairman. I just missed that one. It should just be the straight NAC 706.360. I've already made the corrections on my copy. And in conferring with Ms. Kuhnel, that is her recollection of it as well.
Okay, so let me ask you one other question, Ms. Wilburn. Under item 2, it says, Mr. Carson questioned Ms. Babcock about the tariff respondent submitted with its original application. It was bait stamped. And then we have bait stamped again. What is bait stamped?
It's the stamp on the bottom right-hand corner of a document. It's a court term. They stamp it so you know which number and whose exhibit it is.
Okay, it's not date, it's bait.
No, the bait is the correct word. Yes.
Okay,
Yeah.
perfect. Okay, I just wanted to, I had not noticed that before and new to me. Perfect. Okay, so Mr. Carson, what are you asking us for?
Well, I mean, obviously, what I had asked for at the hearing was that, okay, there is a discrepancy, and we all admit that the CPCN says this, and we all admit that the tariff says this. Everybody admits that they normally, in positions such as this, one of them would have been corrected prior to the actual CPCN being issued. So my question is if it escaped me, it escaped Ms. Babcock, it escaped all the commissioners who voted on this application, it seems kind of a little bit heavy-handed to just blame it all on me or the respondent when it has been that way and they have been operating that way for almost 4 years at that point in time. So I just figured I know how this all started. I'm not going to get into that, but I mean, I think the thing would have been is that, hey, fix one or the other, not more or less kind of an adversarial type of a situation, but more of a, hey, we're helping you. We're not policing you. We're not just want to make sure that you're going to do the right thing and that we make sure that we set the proper precedents going forward. And I believe that's going to be coming up on one of your discussion items, is that which one's going to control? Is it going to be the CPCN or the tariff when a mistake like this happens? This one, I can't remember has ever happened where there was a discrepancy between two legal documents, because we all do know that under NRS 706-311, once a tariff is filed, submitted, and stamped, that is prima facie law. And so if our tariff says we're following the law, which is points and places within the state of Nevada, and the CPCN doesn't, how do you balance between two different laws when we're supposed to, if we don't follow one, we're going to get cited. We don't follow this one, we're going to get cited under. So this, in my opinion, literally was a mistake. I took and we could file, like I said, we did file our expansion of authority just because of the ruling, but it's taken this long to get to that ruling, and that's been since January. So my thing is yeah, I don't think we should have been fined for this. On this, I think it would have been like, hey, okay, file your expansion of authority and get your two documents in order.
Okay.
That's where I'm sitting at right now. And then
Okay, so, but, all right, go ahead, Mr. Carson. You're,
the one last thing, and I'm gonna put Commissioner Zokic, since he's not participating on this, is that they had, the order says 5 unannounced operational inspections over the next 2 years. I've never seen that in my entire life. This particular situation, the enforcement went through over a year's worth of their invoices, transactions, employee files, vehicle files, everything, and found 0 violations of operational with this, except for the fact that there was a discrepancy of where they could pick up or drop off from. I think 5 unannounced operational inspections, when you guys have looked at them so hard in this inspection and found 0 violations operationally. It was just whether or not they pick up. And then that gets me back to our first argument is, I think it was a mistake, but we lost at the hearing. So we lost at the hearing, and I filed a expansion for application like I said I would. So that's where we are.
Chairman, just briefly, Administrative Attorney Yoni Wilburn. I just wanted to let you know, Mr. Carson, and I know he doesn't mean this, he's saying it's a mistake. That was what was ordered, the 5 operational inspections, correct? Like that is what the hearing officer said. There's not a mistake in the order.
100%.
Okay. I just wanted the chairman to know that because it was, like, but that is what the hearing officer ordered was 5. So
That's not a typo. That's something she ordered.
okay. No, and that's okay. So as I recall though, Mr. Carson, if you're filing for an expansion of authority, wasn't there a PLTI filed by, it was either, I can't remember, Churchill or Lyon County Fire? And that's when you guys pulled back to the 5 county geofence?
It was always 5 counties plus Lyons County at that time. But in the original application, we had always had the language that we wanted on one hand and state of Nevada on the other. The stipulation that was entered into was to remove just Lyons County only from that. There was no further geographical restrictions that were placed on that by either the remaining 2 protestants, and one was an intervener, which was REMSA. Only thing REMSA wanted was, we're not doctors. We can only do oxygen and something else, which my understanding is that you guys have recently, in other things, kicked them out as interveners for those very same reasons, is that, we're going to interfere with their ambulance agreement, their exclusive agreement. And so,
Okay.
anyway.
Yeah, Chair, we don't want to get into what REMSA's doing and what we've done in other cases.
No. I understand, but he's claiming that he's filed an expansion, and that's why this should be held back and
Chairman,
dismissed.
and I want to say that expansion is not in front of us. It's here, and I don't think it should be taken into consideration when it's order or not. And Chairman, you are correct on the PLTI issue. It was Lyon County I don't remember the exact organization, but it was
Lyon
Lion.
County Fire. Yeah, yeah. But
Okay.
anyways, okay. So for me, commissioners, and maybe you want to do something different. For me, I'm gonna uphold Commissioner Gibbons' findings on this. I think everybody knew exactly what was happening. I find that Commissioner Gibbons did it correctly. So I'm not willing to reverse her order. That's my position. So commissioners, if you want to make a motion, otherwise you can certainly do that. I'll entertain that motion, but that's going to be my position.
I'll second that, Mr. Chairman, for discussion purposes.
Okay.
My sentiments are very much along your sentiments on this particular matter. But I do also the licensee with some identifying some mitigating circumstances. So based on that, I think for me, I think one of the things that the 5 unannounced operation inspections, I think maybe a little bit over the top. I think anything from 2 to 4 would be more that would be comfortable for me. And as far as the fine, I would be willing to reduce it by $500. So those would be my thoughts on this particular order. Other than that, I agree with the hearing officer's decisions and findings, and I think that her decision is solid. So those would be my comments. Thank you.
Okay. So,
Go
Mr.
ahead.
Teddy, go ahead.
No, go ahead, Chair. I didn't want to cut you off. I'm sorry.
No, you're okay. And I'm not, so Mr. Zoka, just for the record, the 5 unannounced operational inspections, I believe that's May. We don't have to, there could be 5. If staff decides that there are not 5, then I don't think that there's a, and I'm trying to locate that in the order, and I can't seem to find it.
It's item 5 under the order, Mr. Chairman. Page 4. Page 4.
Okay, well, maybe I'm looking at the wrong item because
Page 6, Chairman, under order.
yeah, I'm looking at the order. Oh, I'm sorry, down at the bottom. I apologize. Page 6. There we go. Thank you. Okay. The only thing that I would change, the only thing on item number 5 was that the NTA may conduct, instead of will, may conduct 5 unannounced. I would leave it that. I don't want to try to second guess this, and I'm not willing to support a reduction of the fine. So that's my position. Go ahead, Mr. Teddy.
We had a motion to approve, Chair.
So my motion, and it was modified. My motion is to leave the order exactly as the same or leave the order exactly the same. The only thing that I would be willing to change under item 5 of the order, that the NTA may conduct 5 unannounced operational inspections of the respondent over the next 2 years instead of will.
And Mr. Chairman,
And
we're also
sorry.
would be amending number 3, correct? That it would be no further violations of NAC 706.360 would be what would trigger the abate amount, correct?
And Chairman, that was Administrative Attorney Yonit Wilburn. That was a mistake in the drafting of the order. That is what was ordered by the hearing officers, NAC 706.360 section.
Okay, and you're saying it's for violations of that global fine for the violation of NAC 706.360?
Correct. Or amending the last line where it says provided no further violations. of NRS or NAC 706, it shouldn't say that. It should just
Okay.
say provided no further violations of NAC 706.360.
Yeah, and I have, I think that's just a typographical, and that's okay with me. I don't have a problem with that piece of it, but yeah, certainly we can add that in. But I'm not willing to change the fine, but I am willing to change number 5 to may conduct. And then that leaves it up to staff to determine if operational inspections need to be done.
All right, so Chairman, is that your motion?
That is my motion.
I'll second that motion, Chair.
We have a motion by Hartung. And for clarification, again, no reduction in fine. We will make the changes under item 3. Item number 5 will say the NTA may conduct 5 unannounced operational inspections. And that will allow them, instead of having it will, that will allow staff to do it. So that is the clarification. Have a motion by Hartung, second by Teddy. Let's ask for public comment.
Chairman,
Is there
this a-
anyone? I'm sorry, go
just-
ahead, Ms. Cannell.
Yeah, just to clarify the procedure here. There was an earlier motion which Commissioner Zoka had seconded. Are you withdrawing that motion?
Well, yes, and thank you so much for that. Yeah, my motion was still not to make any changes, but I see the necessary emendations in the text. So yes, I'll withdraw that motion.
Comment
Okay.
online.
Yeah, I'm sorry. So somebody said something about online.
There's a hand raised online.
Okay. Who do we have online?
Hi, Chairman. This is Brian Gilbertson.
Mr. Gilbertson, welcome.
Thank you. I just had a question on the, before you vote on the motion for the NAC code. Is that for picking up outside of licensed counties?
Action get a scope there.
So the public comment is not meant to have a discourse, Mr. Gilbertson. So I'm not going to answer that. I mean, I think it's all in the entire order. My motion still stands to uphold Commissioner Gibbons' hearing and the motion that she made and the orders that she put down with the amendments of item number 3 and item number 5. So you can certainly make your public comments, but that's the motion that's on the table.
Mr. Gilbertson, Administrative Attorney Oni Wilburn, let's have the commission vote on this and then I can answer your question. All right, so there's a
Okay.
motion.
Got a motion.
Chair,
Motion by Hartung, second by Teddy. Yep, go ahead.
No, I just was recapping. I didn't know if you heard Commissioner Teddy's second.
Yes, no, I did. So motion by Hartung, second by Teddy. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously.
Mr. Gilbertson, Administrative Attorney Oni Wilburn, that section is use of vehicles beyond the scope of authority. And that's what they were cited for.
Okay, thank you, Mr. Carson. Commissioners, that takes us now to item number 97, discussion regarding NTA policy that would be considered acceptable with compliance of NRS 706-124, which is taxi cabs.
Chairman,
So-
Bartek,
Yes,
just really
yes.
quickly, Administrative Attorney Oni Wilburn, Brian Hardy, who is the one who submitted some backup documentation on this issue, is in court right now. He has sent an associate. She is here and available to speak with you. If you would
Okay.
like to, Mr. Hardy, we can push it, but she is here, willing and able to speak.
No, and I read Mr. Hardy's, this is me personally, commissioners, and I'll just kind of open this. 124 is clear. It is, and in fact, let me make sure that I've got it in front of me because I don't want to make any errors. I apologize. This is what happens when you have everything in digital format and it's not bookmarked. Maybe someday. Okay, so 124 basically says that, not basically, it says this: taxi cab means a vehicle which is not operated over a fixed route, that's not what we're talking about, is designed or constructed to accommodate and transport not more than 6 passengers, including a driver. And so Mr. Hardy sent a notice that says, and constructed. There's never been a question, commissioners, in my mind about what constructed means, which means modifications. And we've talked about this. When this kind of came to pass, when Commissioner Gibbons and Groover were still on the board, there were a number of solutions that were proffered. And what I saw coming from Mr. Hardy to solve the problem of seating with the cabs here in Reno, I think that's an eloquent solution. I have no problem with it whatsoever. It removes the ability for that vehicle in whatever method. And I think that for me personally, I'll let staff make those determinations when they do the inspections of these vehicles to say, yeah, that's suitable. That's a suitable method, because that may not be the only method that's used. But I loved what they came up with as that console process where it's buckled in and it basically removes the ability to use that seat. So, Miss, I can only see the back of your head. Welcome. And I apologize. Tell me who you are.
My name is Sarah Ethington. I'm an associate that works with Brian Hardy. So he sent me on his behalf and he apologized for not being able to make it here this morning.
No problem. Go ahead and just introduce yourself for the record, and I'll let you make some comments for us.
So for the record, my name is Sarah Ethington. I'm an attorney here representing my client just related to its letter. We agree with everything that you just said, Mr. Chairman, that our client should for a solution, and our client is willing to proceed forward with the manner that we set forth in the letter about installing the console fixture.
Yeah, no, thank you so much. And again, commissioners, I don't think that's the only solution that's out there, and I'm willing to let staff determine whether those are viable solutions when they do the inspections. But I mean, I love that. It's innovative. It solves the problem. You know, we're not here to rewrite 124. Sadly, there's no flexibility. If this was NAC 706-124, we could deviate easily and we could say, look, this doesn't work for Northern Nevada, and we could deviate from it. But because it's in NRS, and what I would suggest that the cab companies do outside of Clark, and maybe even Clark, I don't know, maybe there's a need for it there in order to compete, but at some point, somebody's going to need to ask the legislature to revisit 706-124 for the simple reason that it's certainly, while I know why they put it in, and it was put in originally in '89, which was before the NTA when we were still part of the PUC, but then it was updated in 2015, which makes me believe that it has something to do with the TNC effort of 706A. But that's not what's in front of us today. What's in front of us is to say, look, this is what it says. And personally, I have no issue whatsoever because it's clear or constructed. So that means those modifications, and I would interchange modifications made for constructed. Commissioners, questions, comments?
None from me, Chair. I mean, I think in terms of 706-124, you know, the vehicle has to be designed or constructed to accommodate or transport not more than 6. So however that be done, as long as that's safe, I have no issues with it. Obviously compliance would verify that the modifications are made. You know, my main concern would be if you're gonna make some sort of significant modification, that whatever those be, it be safe to the passengers.
I don't disagree, and but that's where compliance is gonna have to make those determinations and if I would just think this, and this has nothing to do, and we can't reword any of this. If they feel uncomfortable with the modifications, I mean, you know, in other words, if they physically modified the vehicle and the safety standards of the vehicle, they may have to get it signed off by, you know, an approved mechanic that says, yeah, the vehicle is roadworthy. But other than that, I mean, you know, what I've seen thus far is they're not making any modifications to the safety standards. They're just making sure that you can't put additional passengers in the thing. I think it's great.
Yeah, and I'm okay with that console idea also. I mean, I have no objections to that. And, you know, related to the 6 passengers, I share that same concern that, you know, whatever device is there or whatever, you know, limiting devices is placed, it's be not easily removed between rides.
Agreed. Commissioner Zoka.
Mr. Chairman, I completely agree with you and Commissioner Teddy's comments. I think we've talked about this issue at our last general session meeting. I think the 2 biggest things for me is safety and as far as the modifications, as Commissioner Teddy has stated, so it's not easily convertible back to a larger seating capacity. I was very much impressed with Mr. Hardy's letter. I think it was very well put together. And I certainly, this letter certainly appears to be a viable option, but I do agree with you that ultimately the decisions are going to be up to staff. So those are my comments, Mr. Chairman. Thank you.
So I don't know what kind of a motion that we can make. I know we put a moratorium on putting any additional vehicles in, but here's that don't comport with 124. I think 124 stands on its own. It, you know, and if anything needs to be changed in 124, that needs to go to the legislature. That's a legislative issue. And then we will certainly comply with whatever the legislature decides. And that's for, you know, a future legislative session. But beyond that, I think that 124 stands on its own. I don't think that we need to define any of this. And as long as there's modifications that are made to comport with 124, you know, I don't think anything else needs to be said. I don't know what other kind of a motion we could make at this time.
Concern that we had other vehicles above that already.
So, Administrative Attorney Yoni Wilburn. First, I do think since there was a vote to put a moratorium on putting any new vehicles in, I do think you need to take a vote on whether you want to reverse that moratorium or not, because if there's no vote taken, it stands. Second, I don't know that we can address it here, but the vehicles that are already in play that have already been approved, I don't know that they should be called back. There's some legal issues about calling them back that go beyond what we do here, 706, essentially like an equitable estoppel argument, something along those lines, stating that we approved them, they should be allowed to use them since all information was given to us and the agency approved it anyway. So I do think the motion that needs to be made, though, is regarding the moratorium. That should be addressed unless the commission wants to keep it in effect.
Okay, so let's just play this out. The moratorium that's in effect says that vehicles cannot be put into service that don't comport with 124. If this console, hold on just a second, Ms. Cannell, if this console is put in, it complies, it comports with 124. That's not, so I don't think I think keeping the moratorium in place of saying, look, unless the vehicle complies and comports with 124, we're not putting any other additional vehicles into service. You can't go back and say, well, you did it then and you need to do it now. What I don't think is in front of us today is the question of removing those vehicles from past decisions. I don't think that's what's in front of us today. What's in front of us is compliance with 124. And so the vehicles that are in service, they're in service. I mean, what I would say is if enforcement catches them with more than 6 passengers or 6 occupants, including the driver, then, you know, the fines will be commensurate with that infraction. But I think the moratorium stands on its own, and I personally believe that it should be left in place, commissioners, because that was put in place to say we're not going to allow any additional vehicles to be put into service that don't comport with 124. Over.
I just wanted to get into talk about how the moratorium topic is not agendized. Chairman, I think you've summarized what is in front of us clearly.
Perfect.
Additional.
Perfect. Yeah, and again, the moratorium was to all moratorium was designed to do was to say we're not putting any additional vehicles into service that don't comport with 124. That's it. And I think it stands on its own, and I think that that's a moratorium that should stay, period. This modification comports with 124. I think it's great. I don't think that in fact, I don't see a motion that we say, yeah, that we agree with construction, because it's already in 124. I guess we can have a motion that says, yeah, we agree with 124, but other than that, I'm vexed. Maybe someone can, you know, lead me through this. So
This is agendized as a discussion item for possible action, which basically means you really don't have to act on it. And I'm sure unless the applicant has further questions, and if they've obtained their clarification for this discussion, I don't believe that the commissioners are required to act on it or actually gain my motions if needed.
perfect.
Chairman,
Mr. Zucker. Oh, I'm sorry. Go ahead, Ms. Wilburn. I apologize.
I
Didn't mean to step
apologize.
on you.
I do believe there's someone online with their hand raised. Is that correct?
That's correct.
We haven't gotten to public comment yet. So what I want to do is I want to hear from the other commissioners, and then in the second here, I'll take public comment.
I don't know if I have anything further to add. Discussion.
Okay, Mr. Zoka?
I would say the same, and I think the comments we've made on the record last time and this time are pretty clear as to how we view this particular statute, and that we would accept modifications so long as they're safe and they permanently disable the option of that additional seating within the vehicle. So I think with that, I think staff has clear instructions of what we're looking for, and I don't think we need a motion. So that would be my comment. Thank you.
Okay, all right. Thank you so much. And I'm sorry, I think I caught your name as Sarah, but I couldn't understand because the audio is really rough.
Yes, my name is Sarah. Yes, I agree with what you said. My client, Brittany Street, is online, who's the operations manager. So I'm not sure if she had anything further to add.
Okay, perfect. So let's do this, commissioners. Let me ask for public comment. Let's start with anyone in Las Vegas wishing to speak under this item.
I see no hands raised, Chair.
Thank you. Anyone in Reno wishing to speak on this item? Okay, no one in Reno. Is there anyone online? Ms. Street, if you're online, you're welcome to give us some comments, but I'll just open it up under general.
Okay, thank you, Chairman. Good morning. Brittany Street with Reno Sparks Cab and Yellow Cab. Thank you guys for being here today. Just wanted to raise a question and get clarification on record. I know it was mentioned that There is nothing before us today to discuss removing vehicles that have already been placed into service. But my question is, if I have one of those vehicles that are already in service that goes down for repairs from an accident and needs to come in for a safety inspection to be put back into service, will that vehicle now need to be constructed to remove that seating capacity, although it's already been put in service with the way it is?
So I think you've answered your own question, and I'm going to just jump in here, commissioners. Because I know that we're dealing with you directly on this. This is not just general public comment, Ms. Street. If the vehicle is taken out of service because it had to be, repairs had to be rendered, that means it's taken out of service. Now, when it gets put back into service, it has to comport with 124. So yes, I believe that, in my opinion, it would have to comport with 124, even though it was previously in service and did qualify. But because it was taken out of service and then it had to be put back in service, but if you were to sell the company and all those vehicles remained in service, I believe that would still apply to those vehicles that were in service. So they would not have to be modified. That's my opinion, and I'm going to defer to legal.
Chairman, this is Radhika Kannan. Just to clarify, could Ms. Street or Ms. Kingston tell us, put on the record what their relationship is Ms. Street, your client?
Yes, she's the operations manager for Reno Cab, Yellow Cab, Capital Cab, and I'm an attorney that works with Brian Hardy,
Thank you.
representing them.
So her question comes in her capacity as your client.
Yes.
It's relevant to this meeting. Is that correct?
What was not
Maybe
related?
it's-
Yes, related to the item.
Administrative Attorney Yonit Wilburn, I agree with everything the chair just said. If it stays in service, it stays in service. But once it's pulled out, even if it's for repairs, it is taken out of service and must go through the same process as any other auto to be put back in service. So at that point, it must comport with 124, and it would have to be either modified or it would have to comport with 124.
Understood. I just wanted the clarification on record. Thank you.
Seal issue's not clear, depending.
What? Yeah, no, they just don't have.
Commissioners, anything else?
Nothing from me, Chair.
Nothing for me either, Chair.
Okay, the final thing, is there anyone else online wishing to speak on this item?
No other hands raised online.
Okay, so commissioners, I don't think that we need to take any motions at this time. Unless somebody wants to make a motion for clarification. I guess we could make a motion saying that 124 stands on its own, but that if a vehicle does come out of service.
Lost the audio.
Chairman?
Yes, ma'am.
Oh, there you are.
Can you restart your comments? You were frozen for a few minutes. We lost the connection.
Sorry. See, the blessing of technology. So my comments were, I don't think we need a motion, but if we were going to take a motion, we would say that 124 stands on its own. But if for whatever reason a vehicle that was previously put into service that did not comport with 124 had to be taken out of service for any reason, that once if they wanted to put it back into service, that it must comport with 124. That would be the only motion that I could think that we could make.
Mr. Chairman, I don't think we need a motion on this particular item.
Okay, perfect.
I'll second Luke's
Yeah, no, that's fine. I felt the same, but I was going to say if there's anything that we would make a motion on, it would be that.
This guy cannot retire from the agency.
Okay. All right. So, and we've taken public comment. I'm going to close item number 97. I'm going to take us to item number 98, which is docket number 2508019. Updating language. Ms. Babcock, welcome.
Yes, thank you, Chairman. When Attorney Brent Carson started talking about that citation, I looked forward into this item and saw that the latest document was not included. So we've had them printed up. If you want to see if anybody wants those, here's some for the audience, and one is provided for you. And this is staff's latest, and I've given, I think, 4 or 5 different samples of what it currently reads and what I suggest it read in the future.
Okay. So this is all, what you've done here is you've separated out each one of the services, correct, Ms. Babcock?
I tried to find pretty much every type, yes.
Yeah, that's
Just-
lovely. Right, so we're not just picking one, we're just saying current and revised. I love this. I think it's great. I think you've done a great job on this. This has been confusing
That's my earlier
language.
push, Mr. Chairman.
Mr. Zoka, nearly the day I walked in the door, I was confused about on one hand and then on the other. And I thought, what does that mean? It was just,
Well, I think it was written by an attorney because only attorneys can come up with such convoluted language, so.
May I ask Mr. King a question? Are you able to, do you have the capability of sharing this or putting this on the screen? This document that everyone's looking at for the benefit of everyone online, people online?
Can you share yours? Can you put this up and then share the screen?
I do not have this on my computer. Are you able to share this?
What if we had an extra caller and held it before the camera? That'd be possible.
How about I take a picture of an email too? Pull it up here.
It's still, I don't have email on here and I don't.
well, I think, so Jason, so let me ask you a question. You've posted this online, correct?
I'm sorry, Chairman, what was your question?
You posted it on, is it posted online? Can you put it on the website?
It is not posted yet online.
So we did just send one up to Austin. Perhaps
Yes,
he
I have it.
can Austin post it since we, how'd you send it to the factory?
I emailed.
It was emailed up to Austin. Is he able then to put that online?
Let me,
Regardless, there's
I'm gonna,
in
sorry.
between it's posted and when it's available on the
Oh,
website.
yeah.
oh, that's right, there's a dead spot, isn't there?
Yes, but perhaps Austin can join the call, put this on his computer and share his screen.
That is one option. In the alternate, if someone can just read the contents of the document.
Okay.
All
I'm
right,
happy to
If
document.
if I may, I apologize. Hope T. Bartolomeo, Management Analyst. I've asked Austin to share the document and I can try attempting to share for you to have the visual.
oh, Hope, you're a lifesaver, thank you. Go ahead.
Okay, bear with me just a moment.
You need to share a picture of that baby first, Hope. I still haven't seen a picture of the baby.
We'll get there. Okay, this is the document in question.
Yes, thank you. Oh,
You're welcome.
thank you, Chairman.
Okay. Does that suffice? Ms. Kuhnel? Here,
Yes,
Mr. Bomback, here.
Oh, I don't want to take your copy.
No, it's fine. Go ahead. I've read it. No, I find it to be straightforward. I think staff has done an incredibly clear job on rewriting this, and I want to thank them for, Ms. Babcock, thank you and Mr. Hammock for daring to endeavor this, because I know it's been around. You talked, Ms. Babcock, about it being around you've been here for more than 17 years, and it had been here long before that, and nobody questioned it. But I think it's always important to go back and clear up language, especially when there's ambiguities, and you can't always clear ambiguities, commissioners, but What we can do is, to the best of our ability, try to clear them as best as we can, one by one. And it's, I know we're eating an elephant, but you do it one bite at a time. Mr. Teddy or Mr. Zoka, any questions or comments?
None from me, Chair, other than I like what staff has presented for the revisions.
Mr. Chairman, I completely agree with that. I think these revisions are very good. I like them, and I want to thank you for your leadership in bringing this to the forefront and making these revisions. I think it's well needed. So thank you.
No, thank you so much. I appreciate that. And Ms. DiBartolomeo, thank you for sharing all of the things that you've shared now.
Most welcome.
I appreciate it. So commissioners, let's take public comment. Is there anyone wishing to speak at this time? Mr. Kent, Ms. Maxon Rushton.
Good
Welcome.
morning, members of the commission. For the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson. I will start by noting the fact that I certainly recognize that clarification is always warranted. My concern is that the language is not consistent with your regulations. You have specific regulations that define airport transfer service, scenic tour service, and it says between points and places in the state of Nevada. And so if the objective is to clarify that, then I think it requires a regulatory workshop be opened and that you revise it to clarify that specifically for the members of the industry. I also have concerns about the fact that if I have a client that has authority to operate in Clark County and points and places in Nevada, the interpretation has always been that you originate in Clark County, but you may go outside. This says that transportation must originate or terminate within Clark County. So it leads a carrier to believe that they could pick up someone outside of Clark County and come back. Again, I don't disagree that the regulations are convoluted and possibly warrant clarification, Chair and members of the authority. But I think that we've had this issue come up over at the Taxi Cab Authority, and the advice from legal counsel has been very clear. This requires a rulemaking docket. You must open it up and clarify because you have a set of regs that don't comport with this proposed language that you're looking at putting on certificates of authority. So again, we may understand what is the objective at this time and how it's to be used, but I think as going forward, everyone's going to look at your regulations and statutes and that's what they follow. So for those reasons, I strongly recommend that if this is the route that you want to go, that you open up a reg workshop and move forward in that capacity. Thank you for allowing me to make the comments.
Thank you. Mr. Kent.
Good morning, Jamie Kent. I echo Ms. Maxon Rushton's comments. A couple of things I would like to point out as well is that I understand that there's been, if you try and look at it, you've indicated, Mr. Chairman, yourself, and I believe Mr. Zoka or another commissioner previously indicated, yeah, that it seemed confusing. But for the most part, confusing or not, that language has sufficed for many years. And it may be a term of art. And the question I might have, with no offense to anybody, but is it better for them to learn the term of art, or is it better to try and redefine it, make everybody else learn new terms? And, because I look at this and unfortunately, you could probably do this with just about any statute. If you wanted to go find something and pick something wrong with it, you probably could. But when I look at some of the revisions and it says all transportation must originate or terminate within Clark County, Nevada, I'm going to have people contacting me, clients contacting me and say, well, can I drive outside of Clark County though? Because it doesn't say I can go to other places and points within the state of Nevada. It just says I have to originate and terminate. Can I go outside? And I think then, are we going to go into making this a much longer, much more involved definition that tries to use a lot of words to encompass the term of art? One thing I would have one problem is under the first one, it says, all transportation must originate and terminate within Clark and Nye County. I think that might be an or there, because somebody would say, well, how can I terminate in two counties at the same time? So on that first one, I have that particular, but with regard to the others, you know, I hate to have a workshop because it involves more, but I think if you're going to do that, I think I would agree with, if you're going to change it, I think I would agree with the workshop, so that everybody in the industry understands and knows what the language is changing to and why. Thank you.
Okay.
Ms. Ma-
Yes.
Excuse me, Chair, really quickly, Ms. Maxon Rushton, since Administrative Attorney Yoni Wilburn, you've been doing this for so long and you're so qualified to speak on this. Can you show me which regulation were you talking about that says points and places? Or
Certainly.
please, I'm sorry, I'm looking for the
Under
exact.
airport transfer service,
Okay.
76.015, it defines airport transfer charge between airports or between an airport and points and places in this state.
Okay, thank you. And that's 36.
706.016.
015. Okay, thank you so much.
And then, yes, there's similar language with respect to other regulations as well.
Great, thank you so much.
Chairman, if I may,
Please, Ms. Babcock, go ahead.
I want to point out that Ms. Rushton was at one point chairman of this agency about 20 years ago, somewhere around that. I have been here for 18 years and I was instructed on what this means. She just said something that's different than my understanding. So now I side with Kimberly. I hate to beat a dead horse, but because I really thought I had.
Okay.
I understand on the one hand and points and places on the other that one side, either the origination or the destination. And the way she just said it, it was the origination had to be in, but the destination could be anywhere. So that's a difference.
Here, ends here.
But
Right.
does,
That's a
so-
difference.
I'm sorry, I apologize.
Oh, go ahead, sir.
No, I was gonna say, but just because someone has felt that that's what it said, and that the industry says, oh yeah, this is what it said, but I don't know. God, I love lawyers.
Mr. Chairman, may I?
Please.
Thank you. So we had some issues, process-based legal issues raised by the testimony of the industry here. I would like to hear from Ms. Connell and Ms. Wilburn relative to those issues they've raised, what their thoughts are, especially the regulatory workshop, because I think that's something we might want to consider as well. So may I ask those questions of our counsel?
No, and I also have some questions because I don't think what's in front of us is going to change what the regulations say, but I'll just, yes, I would love you to ask those questions. Go ahead.
So I would like to get Ms. Wilburn's thoughts first and in terms of the regulatory workshop and how that relates to this.
So, Administrative Attorney Yoni Wilburn, here are a couple thoughts when we started into this and looking at these. I don't necessarily think, I'm sorry, I gave up my piece of paper. I don't necessarily think this language that is proposed is changing the regulation. I believe it's just clarifying what the regulation means. It's a clarification of what the regulation is asking for. However, on the flip side, I will say that because you've been using this language for so long and it's been in place, I can see why the industry would want a workshop on this to give their input. I don't necessarily, like, again, I don't believe this is a regulatory change. I believe it's just a change on how we're interpreting the regulation and what it should look like. That being said, I don't think a workshop, as much as I don't love workshops and they're a lot of work, as Mr. Kent said, I don't think that's out of the question here, but I think that's something for the commission to consider.
Thank you. So same question for Ms. Connell.
Chairman, and Thank you, Commissioner. This is Radhika Kanal for the record. I agree with Ms. Holborn for the most part. The only part I would add is, I'm looking at the regulations and none of the language that is, presented here conflicts with what's in the regulation. However, if the commissioners are inclined to maybe put together, get the stakeholders, opinions into take those stakeholders' opinions into consideration, a workshop may be warranted, but it's definitely not required. And as to the agenda item, as it is agendized at this point, it's a discussion item. And with for possible action, sure. If the commissioners are inclined to take a motion or potentially exploring the possibility of either a workshop or giving the stakeholders and the industry an opportunity to put in their give their input, thoughts. Those may be two routes that the commissioners can proceed on based on the item that's.
Thank you, Ms.
Floor
Canal.
is still yours, Mr. Zoka.
Mr. Chairman, the only thing I would add also is, it was my understanding that we're not changing, and I would not want to change existing certificates. This is merely for something that's applying today. Going forward, for clear language provided in insofar as their application and the description of the authority they're going to get. So existing carriers would not be having the language change in their certificates. So.
Correct, and that is exactly correct. There was never a question, Mr. Zoka, that we would go back and retrofit any of the certificates. If anything needed to be modified, we would be retrofitted at that time because it would be treated as sort of a new application. But there was never an intent to say, no, we've got to go back and change the language because the language is all wrong. This is just a clarification, and I personally don't think. I think that again, regulation is standing on its own. It says exactly what it says, and that's okay. And this is not an intent to change any of those of the wording in the regulations. I just think that there has been a question, and there seems to be a misunderstanding between what two people think about what this actually said, what this says. And so that's why I was hoping to have some clarifying language as we move forward. If you guys want to hold workshops, I thought that's what these discussion items were sort of pseudo workshops to just go through. And that's why we didn't just use the first iteration. This has gone through several iterations, and again, it's clarifying language for future certificates. Over.
From Chair, from my perspective, I agree that maybe we need to clarify this, but when we make clarifications, I would just want to ensure that those clarifications are in line with whatever the certificate holders have. I would not want to take anything away from anyone through clarification, which I think is part of Ms. Rushton's concerns, is that through some of these revisions, we may inadvertently take someone's authority away through the revision of the certificate. So while I think the language could be clearer, I don't think we can settle on just these 1, 2, 3, 4 revisions. So maybe it's worth having a discussion with the industry related to any changes that we make, just to get input from stakeholders.
Okay.
That would be my take on it. I think we table the item for further
Yes.
Chairman, just to, this is Radhika Kunal. If the commissioners are inclined to actually get public opinion or public thoughts, one way to do that would be actually putting it out for public comment. With this, the document that's presented here on the website and allow certain time frame for the public to comment.
Yeah, I'd like
Maybe
that.
revisit it, but then another next agenda or the agenda after.
I like
I
that.
would recommend at least 30 days to the public comment period to be followed.
To the item.
And
I
we
would
can
use-
certainly do, I'm sorry, Mr. Teddy, we can certainly just stave it off because we might not have 30 days between this meeting and our next, our December session. So we could even push it off until January and take a bite at it then.
I support that, Mr. Chairman. I think that would be a good idea to bring us back in January. Until then, solicit comments from the industry. And again, I think we should also include something in here, making it clear that we're not intent on changing anybody's certificate. This is just going forward for new applicants.
Or modifications to currency.
And the intent here is to provide a more clear language to new applicants as to what their operating authorities are with a more modern language, if you will.
So I'll second that.
Okay, I'll take that as a motion.
Are we tabling this? So what was the motion?
Bring it back in January, or January general session
And solicit comments.
and solicit comments from the interested parties.
So, Mr. Zoka, what I'd prefer that we say is bring it back at our first meeting in 2026, just in case there isn't one in January.
I second that friendly amendment, Mr. Chairman.
Okay. So is there any other discussion, commissioners?
None from me, Chair.
Let me just, okay, thank you. Let me just make sure, is there anyone else wishing to speak under public comment? Okay, I'm gonna close public comment. I'm gonna bring it back to the board. We have a motion by Zoka. Who was the seconder? Because I don't think I seconded it. Did you second it, Mr. Teddy?
Yes, I second, Chair.
Do you agree with the amendments that I suggested?
Yes, I do.
Okay, seconder agreed with the amendment. So we have a motion by Zoka, second by Teddy, with amendments by Hartung. All those in favor, please signify by saying aye.
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 Aye. Motion carries unanimously. Okay. All right. And my comment about attorneys was not pejorative. It's, you guys make us think.
My
Kills me.
feelings are hurt, Mr. Chairman.
Yeah, they should be. I don't want to think, Mr. Zoka. There are thinkers and doers, and I'm a doer. All right. That takes us now to item number 99, docket number 2508022, discussion on updating NTA model tow tariffs. Mr. Bombach.
I'm here for this.
Okay. Ms. Babcock, would you like to open this item for us first?
Certainly, there were 4 LCB items that were approved that affect the towing industry. 2 of them do not affect our model tow tariff, and the other 2 do. So the ones I wanted to bring out are the ones that affect the tow tariff and how the applicants are to go through processing that for those changes. So
I'm
I
gonna-
would.
Oh, I'm sorry. I apologize. Go ahead, Ms. Babcock. I didn't mean.
Okay, so the LCB file R04023, while it has some changes for tow authority, it doesn't affect anything that's filed for a tariff modification. We have, let's see, for LCB R042-23, which has several items that will affect the tow tariff modification. And let's see. I can start with that one if. I'm sorry.
Okay. Yeah, and that's what I have. It adds CPI-based annual rate adjustment, a DOE fuel surcharge authority, and allows recovery cost charge. And it removes my sign off for discounts.
Well, category C is now allowed to charge mileage, which they were not before. Well, they were on flat rates, but now all category C can charge mileage rates. So that involves making a way for the hourly carriers to apply for that category C mileage, which would be to add a rate to their tariff.
And you're
Because
in,
there's no-
you're in RO 4223, correct?
Yes, 42-23, section 2A, section 1,
Okay.
item 2A.
Okay, perfect. I just wanted to make sure that I was in the right.
Okay. Yes, they can add a page to their tariff since there's no way to add it to the tariff. And then in section 2B, they may now charge for recovery. And that's an easy one. We just make those lines fillable on the tow tariff itself, because originally they were not permitted to do that. So they were Xed out in those sections. Now those will be fillable for them to add those rates. And then section 2C is where they can now charge a fuel surcharge, which is the same for A, B, and C. And in section 2C, it just talks about C is similar to A and B. So when we get to the other one, we'll discuss the fuel surcharge, which is also in this one, item, let's see. I'm sorry, there's so many pages to this.
Oh, I know. I'm shuffling here digitally.
So the
Mr.
tow
Baumbach is
association,
shuffling physically. Go ahead. I apologize. Bad.
the tow association very helpfully submitted what they consider to be charges that would be used for the fuel surcharge, the different categories, I should say, such as converter, gear, dolly, and so on, which are marked on those copies that were in the backup materials. Okay, staff, which are accountants, by the way, who do this. So needed a lot of help in determining what was what. And we've presented it as they have. So that's everything that they have submitted is lined in blue on these forms. Staff has no issues with what they're presenting.
Perfect. Okay, so I guess the question, the question here now, commissioners, we can let staff go through these, item by item, because we've got, RO 4023, RO 4223, RO 4323, RO 4423. I think that's what's in front of us today, correct? None of the others, because they apply to 4477 and some other stuff, which is not model tow tariff. So those are what is in front of us. Do we want to go through these individually and vote on them individually, commissioners, or do we want to take them sort of as a whole, where we look at each one, but we take one entire vote? And I'm okay with either one. I do have some questions as we sort of dig down into this stuff. And one of my main questions is, and this is not pejorative towards the tow industry, but it's auditability. If that's a word. We want to be able to audit easily. We don't want you to have to dig out hundreds of documents to do a simple audit where we can say, oh, well, here it is right here. So, and I think that.
I agree. Michael Baumbach, Nevada State Tow Association. I agree. The changes the LCB have put in place are needed. And we talked about this, 2 years ago in 2023? But it leaves some holes as to how we apply some of these things. And I think industry wants clarification too. So we know how to operate in alignment with staff. So it makes it easy for us to operate and easy for you guys to inspect.
Okay. So Ms. Babcock, how do you want us, and maybe this is also a legal question. Do you want us to vote on each one 4023, 4223, 4323, 4423, or what would you, what's going to make it easier for staff? And of course, I want to make sure that there's clarity for the tow industry.
Chairman, this is Radhika Kanal. Was that a question for me or Mr. Walker?
Let anybody, it's a question for, you know, look, I'm open to any answers on this stuff because it is, on its best day, it is complex. There's some very, very complex things in this, and if we try, and hopefully we can do this somehow, some way, try to apply Occam's razor, which is the simplest answer tends to be the correct one, and that's where I'd like to get, so that not only is it simple for staff to audit, but it's simple for the tow industry to calculate, and then if we have a question in terms of how those tariffs were calculated, they can come up and they can say, this is exactly how we did it, and we go, okay, that perfectly makes sense, and that comports with the requirements.
Chairman, Administrative Attorney Yonique Wilburn, on one of the, it looks like it says on the top of the page, it says LCBR 042-23 item 10. On the bottom of that page, it says staff's questions, concerns. I believe if the commission answers those questions and concerns, it will actually alleviate a bunch of this, because I think that's, if we have an understanding and the industry has an understanding of how the commission is going to look at this. For example, is it calendar year versus fiscal year? Is it,
Right.
Are they filing at the same time? Does this have an effect on the filing of other increases? I think if you answer that, that gives great guidance to how the industry should be filing their things. So I think start there. And if there's anything left over, maybe move along. However, I think it's just at this point, it seems pretty chaotic with all of these papers and all of these things. And I understand clarification, but maybe start with answering those questions. And I think it might alleviate a lot of the concerns.
So let me start with this, calendar versus fiscal. And I think most businesses want to run on a calendar year because that's how their taxes are applied. Is there a question as to what calendar year means? Because there's not a definition in 706 as to what calendar means, but 706 NAC 706-2471 does allow us to adopt federal standards. And while there isn't one that we've adopted, 49 CFR 243.5 defines calendar year plainly and unambiguously as that it means the period from the time beginning January 1 ending December 31. And then also if we look at NRS 482, which we do adopt many sections in 482, which is a DMV section, it also says that it's December 31 to December 31. So it's 12 p.m. So it's technically the same thing. Ms. Babcock, because I know we had this, we were talking about what a calendar year means. Does it go, each month, November to November, or?
Right, the reason that I questioned it is that if you go online to the site for the Consumer Price Index, it will show you the most recent month in comparison to 12 months prior and what that percentage is. So my concern was, are we just having them go in, find out what it is once a year they can take that, or are they going to have to go, in this case, back to right now, 2024, even though that may be 2.5. And if you look at last month, it might be 3.4.
Chairman, I apologize. Administrative Attorney Yonique Wilburn, I just got a message from a member online stating they can't hear us. So I just want to make sure. Miss DiBartolomeo, can you hear us?
I can hear you guys just fine.
Okay. Is anyone else online having an issue hearing us? If you can you raise your hand for our staff to see?
How will they know?
Huh? I know. How will they know? I know. You're right. I'm sorry.
I'm sorry.
But
I don't mean to be the.
No, but we have a
Captain
chat.
Obvious.
We have a chat option.
Okay.
And someone is raising their hand. They can. Do you know who that is?
Brian Gilbert.
Brian Gilbertson cannot hear us. Sorry, I just wanted to make sure that the audio is clear for everybody online if they can.
Yeah, no,
So-
I don't disagree.
Hi, it's Brian Gilbertson. So it does cut out occasionally, but if you go out of the meeting and log back in, it brings it right up.
Okay, thank you.
Yeah.
Yep.
Thank you, Mr. Gilbertson. Yeah, Gilbertson, and yeah, that's just a foible of the system. There's even a lag from here to Vegas. And that's why I apologize when I step on people. So hopefully everyone can hear us. So again, how do we want to approach this? And I mean, I know that it's complex. Mr. Bombach, what would you guys like to do? I mean, we think you've done a good job. I mean, as I looked at this, it makes a lot of sense, but again, I want to make sure that an auditing function and features simple. I know Ms. Babcock had an idea of putting certain things right on a receipt. There was a whole bunch of things that she thought were good, which I think makes sense. That way people know what they're being charged and how they're being charged.
Michael Bombach, Nevada State Tow Association again. I think it makes sense to talk about each one of these things or vote on them for each line item, as that can give us the greatest clarity between regulation and industry. When it comes to the Consumer Price Index, we have a few questions that aren't addressed. Ms. Babcock, you mentioned some of them as how long is that period addressed for? Is it from the most recent tariff submission, or is it just for a 12-year period or a 12-month period? What CPI do you actually use? Do you make it an average of all regions, or do you just assume West region, or do you assume Southwest, Midwest, Northeast? There's no clarity on that. And then the other question would be, does the NTA expect the carriers to submit a tariff revision each year annually, or is the NTA going to adopt a specific number for that calendar year that industry is supposed to use? One method is going to require you guys to review applications for about 80 carriers. One would be a way for you to publish something that all carriers can adopt. My recommendation would be that the NTA decides what that number is based on whatever calendar year you decide is appropriate, and we move forward with that. That, I think, is kind of Occam's razor approach for the CPI question.
Chairman, Administrative Attorney Onit Wilburn, I've had a couple, unfortunately, discussions over here with the other commissioners. I think this is extremely convoluted. I don't think we can go through this line by line today, as this is just being brought up. I don't know if the industry has had time to look at what has been proposed. I think that we can't give a specific answer today. I think that would, these are just my concerns. The regulations are out there. And I don't think you can, in an hour, just say, yeah, this is what it should be, because I think it takes a lot longer than that. These are just my concerns. I'm concerned we're going to go through this and just pick and choose to get through it without, Liz, what do you say?
Or do that, or we just take these in bites through upcoming agendas, you know what I mean?
Well, here's my thought on it. These are passed, these are effective, and
Correct.
nobody's able to use them unless we can figure out how to do that. So that's costing the carriers money that they could now have already been charging for like the CPI or whatever, the fuel surcharge, certainly. But there's just a whole lot to it. So I don't know if you want to, like, I wouldn't suggest a workshop. Because,
No, I wasn't suggesting. a
oh,
workshop.
okay.
No, I
because
just,
this is after the fact, but
right.
maybe some kind of a meeting to go over it, to prepare it. I'm not sure how we could go about it, other than step by step each one.
I mean, I think today we can.
And maybe that's too much to do at this general session.
Chairman, this is Radhika Kanal. Can I just make a suggestion to trail
Yes,
this?
please.
Talk to Ms. Babcock and maybe bring it back up towards the end of the agenda to see if, to confirm with the staff, see what their decision is and come up with a recommendation on what to do with this item.
Okay, Yeah, was that question was towards Ms. Babcock?
No, it's a suggestion to you, Chairman. Trail the item for later.
I'm having a very difficult time understanding you, Ms. Canal. I apologize.
Chair, her suggestion is to put a pin in this and trail it till later and come back to it. Continue on with the agenda and then circle back to this.
Or maybe take a short break so I can confer with Ms. Babcock and see where the staff's position is and come back with a more, do I have an understanding of what the staff actually requests?
Okay, and we can take our lunch now and come back at, say 1:15.
Oh,
2 hours.
that's a 2-hour lunch, Chairman.
Oh, I'm looking at the clock on the wall. Sorry. Nobody.
Take a 2-hour lunch.
No,
I'll second that motion.
absolutely not. This,
No. Mr. Bomback, would you please verify that the chairman can tell time?
It is.
Okay.
The clock is still thinking we're in last week. We'll fix it out.
I apologize. I'm like, yeah, well, it went pretty fast, but okay, here we are, noon. No, okay. I'm so,
maybe just take a 5 to 10 minute break at this point because we have a lot still to get through on this agenda. I think taking a lunch right now is a little premature.
and I apologize. I thought it was after 12. Again, I'm looking at the wrong time. I'll go ahead and assume that responsibility, that the clock is wrong, but I'll note for the record that I can tell time. So yeah, let's do that. Let's go ahead and let's just take it's 10 after-ish. Why don't we just go until 11:30 as a break and we'll come back at 11:30. Is that okay?
Thank you, Chairman.
Thank you.
Okay, we're on recess till 11:30.
Please. No. No. Same question. Well, thank you.
Yeah. Yeah. Yeah.
Yeah.
So yeah.
Yeah. Everything makes sense to me. I think, Oh. It's still big. This is one meeting. Right back.
Hello?
Yes, sir. We're on recess until 11:30. Can you hear us,
Maybe he's the one guy that can't hear us.
sir?
Juan, it looked like he just muted himself, so
Okay,
He
But
might
I
be
can hear
talking
you
to
just
someone
fine.
else. in the room.
okay, thanks, Hope.
you're welcome.
I'm sorry, I heard we're on a recess till what time?
11:30, sir.
Okay.
And that would just be, I think it'd be really difficult.
Yeah.
Okay, are we about ready to reassemble down there? Okay, everybody in place? I'm going to call us back to order. Mr. Bombach and I had an opportunity to sit here and chat for a few minutes. And he brings up some really, really good points. And I'm going to let him just make these suggestions to us. But I guess the one suggestion is, as far as a calendar year is concerned, we all agree on what a calendar year is, which is, December 31st to January 1, which we can find in statute, and it is nationally recognized. So we agree on that piece of it, that's what a calendar year is. And then we post once a year those CPI, the average, or the average of that CPI for an entire year on the website. Then that way we would not have to have this conversation with 75 or 80 different carriers. And then I am for adopting the West, because he gave me this data sheet. It shows Southwest, Midwest, Northeast, South Atlantic, Mountain, North, East, North Central, New England, South, blah, 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 Pacific, West, North Central. I am for adopting the CPI index on a regional basis of the West, and then, of course, do the monthly fuel surcharges. So that would be fairly simple. And then the final thing is, and Liz, this is something you and I talked about, potentially have something on a receipt where we sort of know what the tariff was and how it was calculated. So, Ms. Babcock.
Chairman, this is Radhika Kanal. The staff and the administrative attorney and I had a conversation while we were on the break. And as the agenda item, as it's listed, as it's set forth, the agenda item does not actually provide full and complete notice to the public on all the topics that are being discussed at this point. So for the benefit of, to comport with the OML, my recommendation is to continue this or table this agenda item to the next or to the future general session, so the staff can actually bring in specific information and bring in agenda items that are provide more complete and clear guidance for the public. And the staff agrees.
Okay. I don't know why we're dealing with LCB file 4023, 4223, 4323.
Sure.
So
Chairman,
hold on just a second, Ms. Wilburn. Hold on. I'm frustrated here because I think that we've seen this more often than I'd like to, where we don't have complete language in these agenda items. But what I'm gonna agree for the purpose of allowing Mr. Bombach to make suggestions to us that can be brought back so that we can make decisions and notice this correctly. So go ahead, Ms. Wilbur.
Administrative Attorney Yonique Wilburn, I just had a few concerns as we started in on this discussion. It seemed to be heading into, and I know that we do need to make some decisions on this, but it seemed to be heading into the position of an advisory opinion, which, you know, I am not a fan of. And it also seemed, it's just the way it's read with this one. I understand it says these LCB files. These files are very complex, and it doesn't specify what specific sections we're looking at with regards to 40-23, 42-23, and 43-23 because, or 43-23, I apologize. It's not specific enough to understand what it is. The regulations are there. They've been codified. And at this point, I think it's the commission's job to answer staff concerns as to how to look at it, not necessarily adopt what the tow agency wants at this point. So I think we're just not agendized correctly here because staff wants to know how to look at this. And as the commissioners sit here, yes, we do have an obligation to the industry. However, staff wants to know how to address this. So it's important to address staff concerns, but I don't love venturing into the realm of giving an advisory opinion or adopting stuff from the industry in a discussion like this where it's been noticed along these lines, because it doesn't look like that's what it's been noticed as. I understand the backup material was provided, but that's not how the notice has been written.
What I'd still like to do though is I want this to be a simplified, consistent process so that everybody in the tow industry sort of knows what the expectations are. And I think the tow industry is desirous of that also, of wanting to know what those expectations are as far as the NTA is concerned. So here's what I'm going to do before we close out this item and table it. I want Mr. Bombach to go down the list of things that he has of his suggestions that staff can contemplate, and we can try to make some determinations as to what this really looks like from the perspective of giving guidance to staff in the future. So Mr. Bombach, I'm going to give you the floor. Go ahead.
Of course. Michael Bombach, Nevada State Tow Association. I would argue as well, since it's noticed as LCB file R040.23, etc., if you have access to read those LCB files, you know what's contained in there. I don't think there's any confusion there. But as far as what industry may benefit and what the NTA may benefit from, you have a few options as an agency on how you can interpret some of these changes and what you guys can do. Our recommendation is be proactive in what the CPI increase needs to be, release it and publish it so industry knows on your website on an annual basis, and then we can go forward with it. And you're not going to have a bunch of 80 different carriers applying for something all in January, right? Our time's already precious. You don't need to lose more time doing the same thing 80 different times. When we talk about the fuel surcharge, you have the ability to update that weekly or monthly. Our suggestion is to update that monthly the same way you do it for the limousine carriers with accepted fuel surcharges. That allows the NTA to publish what the numbers are for a given period. It allows carriers to look at that. And then to the chairman's point, you're able to audit that information if a question were to come up, and it's going to make it easier for the public to understand and for enforcement to understand too. If the regulation doesn't say you have to do it weekly or monthly, but we can choose to do it monthly. Understand that for ease of operation, for industry side, and for your side as well.
Oh,
that's most of it, Chairman.
You want any other comments, or is it still yours?
I would ask, as it stands, are tow operators allowed to charge a fuel surcharge now? And if they're not, what do tow operators have to do to be allowed to charge a fuel surcharge?
Chairman, all I can say is these regulations went into effect December of 2024. Although they are not codified in the NAC, they have been stamped by the Secretary of State. So these regulations are in effect. As to Mr. Baumbach's last question.
Okay. So, yeah. In charge of fuel surcharge apparently.
Okay.
Okay, so before I close this out, Miss Babcock, do you have any questions of Mr. Baumbach that you want some clarification on before, so that you can bring things back to us? Or do you want to work with him offline?
The only thing I would say is that if they are filing for the fuel surcharge, that would be a tariff modification, which I have the deputy commissioners okay to put your all notices, all of your carriers on the same notice, but then you would have to work that out with the carriers.
Okay. Michael Baumbach, Nevada State Tow Association. The association has no issue noticing for the sake of convenience and price reduction, so we can gain economies of scale doing that. But correct me if I understood this correctly. So at this moment, tow operators are not allowed to charge fuel surcharge until the tariff gets changed to incorporate the fuel surcharge?
That would be correct. And then
Okay.
I would also ask that the carriers put on the billing where they charge the fuel surcharge, the method that they use, how they calculated it for the purpose of our audits and our operational inspections.
If we do it that way now, does that affect the ability of the NTA to decide proactively what it's going to be on a month-to-month basis, if that is indeed the direction you want to go?
Chairman, I believe this is now deviating from the agenda item. Maybe they can meet offline.
Okay.
If you have questions.
Okay. So yeah, just circle back with Ms. Babcock. All right, commissioners.
Will do.
How much time do we want to take this item up next month? Do we want to take it up next year?
Oh,
I mean,
I think next month is acceptable, Chair, unless anybody opposes that. Staff seems to think they can get what they need done by next month.
Okay. All right, so I don't even think I need a motion. I'm just going to table this item until next month. Can I do that, Ms. Kuhnel?
Yes, Chairman, this is.
I'm going to table this item until next month, where staff has an opportunity to bring some additional information back, work backwards with the tow industry, and let's make sure that we have clarity on the wording on the agenda item so that we're not put in this position again. All right. I'm going to close item number, actually, let me do this. Is there anyone online wishing to speak on item number 99? I'll give you an opportunity because we did open it up under public comment.
No hands are raised online.
Okay, I'm going to close it. Anyone in Las Vegas?
No one approached the table, Mr. Chairman. This is Commissioner
Thank you
Zocca.
so much. All right, and I know that there's nobody. Do you want to make any public comment?
Certainly.
Okay.
Michael Baumbach, Nevada State Tow Association again. I just want to thank you guys for the hard work that you do. I want to especially thank Miss Liz Babcock. You answer all my questions, and I know I can be quite demanding sometimes. And I appreciate you giving us a voice and you talking back and forth. It doesn't go unnoticed.
Thank you, Mr. Baumbach. Okay. All right. Thank you so much.
Thank you.
All right, item 99 is now closed. We're going to open up, we're going to go to commissioners' applications for necessity for certificates of public convenience and necessity to provide tow car service. That's items 100 through 105. I know there's a question on item 100. So Ms. Babcock, go ahead.
I apologize for the interruption, Mr. Chairman. I'm going to need to ask, I'm assuming that you're gonna take the rest of the items 101 through 105 in a block vote.
Yes.
The reason I'm saying this, because I need to recuse myself from item 100. I was involved with discussions of the applicant's representative. So on that basis, I'm gonna recuse from item 100. Thank you, Mr. Chairman.
Okay, very good. Well, we're gonna hit 101 through 105, which you can stay on. So
Yes.
Is there anything other than the typo on 103, which has already been noticed, Ms. Babcock?
No, sir.
Okay, let me do this. Is there any public comment on items 101, 102, 103, 104, or 105?
No
Okay.
hands are raised.
Perfect. Mr. Teddy, I'm looking for a motion as a block.
I would, motion to approve items 101 through 105 on the agenda.
Second?
Okay, so that's right. You're able to participate only on item number 100. I apologize, Mr. Zoka. I didn't mean to exclude you. So I have a motion by Commissioner Teddy, second by Commissioner Zoka. We have asked for public comment. All those in favor, please signify by saying aye.
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 Motion carries unanimously. That takes us back to item 100, which Mr. Zoka, you will recuse yourself. That's docket number 24-12017, the application for Exotic Luxury Auto Carriers, Inc. for CPCN. Ms. Babcock, go ahead, take us into this.
Yes, this particular application was on our July general session. And at that time, it was brought up that there are two owners, a 90% owner and a 10% owner. The 10% owner was to be a silent partner. However, he was very much involved with compliance in the processing of the application. So he was asked to provide his fingerprints since he would be involved, and he refused to do so. It was tabled to the next general session to allow time for them to complete that. That was not completed. We did not have another general session until October, and it was on the October 9th, or maybe the October 10th. Now I'm not sure. I'm sorry. General session, at which point it was denied by a vote of the commissioners. However, the applicants stated that they were not advised that it was going to be on the agenda at that time, and so it is brought back here today for the same thing. I noticed Ms. Chan was on the screen earlier, but I don't see her name now, and I don't, any of them are present.
Well, this is thank you, Ms. Babcock, for that.
Chan, she is there.
Hand raised.
Okay. This is clear to me. We have a 10% ownership. NRS 706.391 sub 5 sub A is very clear to me that owner must submit to a full set of fingerprints. And so Ms. Chan, I'll give you an opportunity to have a conversation with us, but I'm just going to tell you NRS 706.391.5A is very clear. So Ms. Chan, go ahead.
Hi, Mr. Chairman. Thank you for letting me speak. I just wanted to summarize this for you guys that in the very beginning of the process, we were told by the attorney that I had hired and who had submitted the original application that the 10% owner, who is Mr. Bailey, did not have to get his fingerprints taken. So moving forward with that, we had confirmed with Ms. Desiree Main, Chief Compliance, and via email, as she spoke with an attorney within your guys' system, and also stated that he did not need his fingerprints done as well. So that's where we're at now as far as the confusion, I guess, that he still needs to get his fingerprints taken.
Okay. Well, I can't speak to advice that your attorney gave. You're saying that you have in writing from Miss Main?
Correct. It was in several emails that she had asked me to confirm that Mr. Bailey was only 10%, and I had confirmed that.
But, well, I can't speak, I haven't seen the emails, so I can't speak to them, but what I can speak to is NRS 706.391 sub 5 sub A. Ms. Main, welcome.
Hello. As our name for the record, Mr. Bailey communicated with myself and my investigator that he did not want to have his fingerprints taken. And he had told him that because he was so involved that he absolutely needed to have them done. They insisted that the application continued to move forward. So what I did was I had her put in writing a statement that he would not be involved in the day-to-day operations of the business. However, he continued to still attempt to contact us. And with that, we moved the application forward to general session to be voted on.
Okay.
Chairman, Administrative Attorney Yoni Wilburn, I was actually in discussions with regards to this because I needed to advise you guys. So I was trying to figure out what was going on here. And I heard what was going on with regards to this application. And Mr. Bailey is his name. He is the one who was doing all of the phone calling, all of the asking about everything that was going on. He was inserting himself in every step of the application, every way. So he is not what you call a silent partner, as stated as a silent partner is someone who essentially just puts up the money and lets someone else run the operations. So I did talk to Ms. Main and I agreed with her and Ms. Babcock that at this point, because Mr. Bailey was so involved, he was not a silent partner and actually was a very, very present partner who was going to be involved in the day-to-day. And I was going to advise the commission that his fingerprint should be taken at this point based on the regs and statutes.
Okay. Okay. Ms. Cannell, would you like to give us any other information?
Just based on, so Chairman, this is Danny Morgan. Based on what I see, what's in front of me, Your Honor, Chairman, I feel like there's a discrepancy between what's represented to what was actually being actioned on, in the sense that the person, Mr. Bailey, is represented as a 10% owner, but it appears that he is acting more than 100% owner. So given that, based on the actions that have been put forth from Mr. Bailey, and even after the owner, Ms. Chan, was given an opportunity to provide further explanation or clarification, apparently that didn't stop Mr. Bailey from calling the staff. So it is clear that the staff is confused as to their roles and the commitment to the business. I guess that's where the staff's position, that's the staff's position, is that right?
Chairman, if I may.
Yes, please, Ms. Babcock.
I had a call from Mr. Bailey regarding this, in which he was quite adamant, raised voice, very argumentative as to why he should have to have his fingerprints done, and that he wasn't going to do it. And I told him he should appear here and make his case that, before the commission, because they would vote on it. There was nothing that I could do than that he should appear here today. But I don't know.
Mr. Chairman, can I also intervene? He is.
Hold on just a second, Ms. Chan. Hold on. We're still discussing it. I'll give you an opportunity. Give me a moment if you would, please. Thank you.
Okay.
So Ms. Babcock, you made it clear to him that he did need to have his fingerprints taken. And this is not something that's discretionary. As I read the statute, again, 706.391 sub 5 sub A, that's the statute that cannot be deviated from. There's a requirement there. And maybe is there a different statute, Ms. Wilburn or Ms. Cannell, that I should be looking at?
I think there is, sir, because this is a tow application. It would be NHC 706.1376 or 77. I think 76. But how it works is if they're not 15% or more, or it doesn't affect control, then they're not fingerprinted. However, we do fingerprint the people who are involved, even though they're not owners, if they're managers, if they're involved in the day-to-day operations, they are also fingerprinted. So it's not
Okay.
based on his ownership percentage, it's based on his involvement of what's going on.
Okay.
And that would be NRS 706-1376.
I'm sorry, say it again.
NRS 706-1376.1.
NRS, okay.
No,
1376.
NAC, I'm sorry.
I was gonna say, yeah, there wasn't anything.
All of that. So NAC 706, 1376, 1A. 706, 1, B2, Your Honor. Chairman.
Okay, hold on just a second here. Let me get to the right page. Oh, what fun.
The owner said.
Oh, other than tow car, my bad, okay. Got it. And this is a tow. Okay. All right, so go ahead, Ms. Chan.
Yes, so Mr. Bailey is on this session, in this session via phone, but he is not somehow able to speak. Is somebody muting him or what's going on? I'm not understanding. And also, in regards to the 90% and 10%, in where does it state that him calling for an update says that he's more than 10% is a little confusing to me. I work full time. So I gave him permission to just call for updates because during 7 to 7, I'm at work. So getting an update, to me, I have been calling and calling and I had not heard back from the NTA. So time to me, I just didn't have. So that's the line that where we're at. Like, I don't understand why somebody else cannot call to get an update. Not saying he runs my company, day to day. He does not. So
Chairman?
what's the thin line between that?
Chairman, Administrative Attorney Yoni Wilburn, there is no thin line. It's actually very much stated in the NRS, not the NAC, 706.4463 2B. Submit to the authority a complete set of fingerprints of each natural person who is identified. This doesn't even talk about 10%. Doesn't talk about percentages at all. Who is identified by the authority as a significant principal, partner, officer, manager, member, director, or trustee of the applicant, and written permission authorizing the authority to forward the fingerprints to the central repository for the Nevada records, et cetera, et cetera. That's just stating how to do it. Based on Mr. Bailey's actions, he fits all those categories. A significant principal, partner, officer, manager, member, director, or trustee of the applicant.
Nowhere in the beginning, nobody had told us that Mr. Bailey could not call and just check for updates. And then also, someone keeps muting Mr. Bailey for some reason where he can't even raise his hand to speak.
Nope, I don't think there's anybody muting Mr. Bailey at this time, Ms. Chan. I don't think there's. Jace, go ahead.
If Bailey is calling in by phone, he can unmute himself by pressing *6.
Okay. Let me let him know.
706.4463.
Chairman, also, just to add, this is Radhika Kunal.
Yes, Ms. Kunal, go ahead.
The staff has clearly represented to the applicant as to staff's policies and procedures on taking fingerprints. I believe the issue is not about it. The applicant intends to make legal arguments. Of course, the commissioners have the discretion to continue this argument as to approval as to the approval of the approval of the agenda item. However, I believe if the discussion is about the legality and the argument on the staff's processes and the procedures on obtaining fingerprints, the staff has been more than clear and transparent with the applicant. And the staff has represented their position as to the process, the standard operating procedure on obtaining fingerprints, which the applicant had plenty of notice.
Hello,
No, yeah, hold on a second, Mr. Bailey. Yes, we can. And I will correct myself, and Ms. Wilburn, you're right. It's 706-44632B. So it is very clear. So, Mr. Bailey, go ahead. Floor is yours. Mr. Bailey.
Hello.
Go ahead.
I think there's some type of technical difficulty because his phone keeps muting, even though Jace is telling him to press *6, and he's been doing
Hello,
that.
can someone hear me?
Yes, go ahead.
Yes, sir. Can you hear me now?
Yes.
Perfect. So I'm a little confused here because I'm the finance guy, so I'm the money guy, and I have several businesses that I do this with. And to be quite honest with you, anyone that has millions of dollars invested into a project is going to be inquisitive, especially when we had an attorney that originally started this process. The attorney sent over everything you guys asked for. Okay. Now, after speaking with Martha, Desiree, right? No one called us, no one emailed us for months. Okay. The only reason why I called was because Ms. Chan asked me to call to reach out to you guys, simply because no one contacted us. Now, keep this in mind. I wouldn't have to actually call you guys if someone reached out to us and just gave us an update on what was going on with the application. The attorney that we had, which is Leah Martin, reached out to you guys several times. She had problems getting callbacks from you guys. So it was times that I have emails from the attorney that reached out to you guys several times. It took you guys 2 weeks to call her back. So the reason why you got multiple phone calls from me is because I'm the person that put the money out there. We had trucks purchased, ready to hit the road. Now, I'm not sure why this process is where it's at right now, but unfortunately it is. Now, anyone, and I'm going to repeat this, anyone that has money tied up into a project that is on a standstill, we're going to ask questions about that. And that's kind of where we're at right now, which is why you heard from me. Because no one reached out to us for a very long time. No one. And then we spoke to
Mr. Bailey, Mr. Bailey, if the dad needs to speak.
We spoke to Ms. May on several times. We spoke to Ms. May several times via email and over the phone. We were told by her during the process, which you guys.
Mr. Bailey, pause for a second. If our DAG has to speak, please let her speak in case we have an issue.
Hold on, Mr. Teddy. Let him complete his thoughts. It's okay. It's okay, sir. Mr. Bailey, go ahead. I'm going to give you about another minute.
Muted me.
Chairman, Mr. Bailey just represented that he has an attorney in place. If he's represented by an attorney, we need the attorney to be here. So it's unclear if they're not represented by an attorney, of course, they can continue the conversation, but we need that clarification before this conversation continues, Chairman.
Okay, all right. That makes sense. So, Mr. Bailey, go ahead and complete your thoughts.
So I couldn't hear what you guys said because for some reason my phone keeps getting muted. I don't know what's going on, but it keeps coming up on the screen that the phone is being muted by somebody. I'm not sure who's put me on mute, but every time I mash *6 in 2 seconds, it mutes the phone back. So that's why you guys can't hear me and I can't hear you guys. But I'm going to finish what I was saying. On several occasions, we spoke to Ms. May in regards to this application, okay?
we were told by the attorney that was speaking with Miss May and Martha that there was no fingerprint. That's why you guys didn't get fingerprints from me. So that's the facts. Okay, that's
Okay,
number
all right,
one. That's
hold
the
on,
facts. So
Mr.
we were
Bailey.
told.
Mr. Bailey,
Go ahead.
hold on, sir. Hold on. If you've been represented by an attorney and you're represented currently by an attorney.
We're not represented by attorney, sir, right now. We actually closed because the attorney kept literally, we will be in charge. Every time she reaches out to you guys' email, we will be in charge, and no one was getting back to her. So no, we don't have an attorney right now. We actually had to depart ways with that attorney, which is why we're here having this conversation. So at that point that we submitted the application or the attorney submitted it, we were told by your staff over there at NCA that based on the certificate of ownership that I needed to know that there was no prints needed from me, which is why we're here.
Okay.
If you guys stated that at the beginning, you would have got your fingerprints. But unfortunately, it wasn't stated, which is why we communicated via email, and we submitted. I know for a fact Vicky Chan submitted emails to the Attorney General that was involved in the case, Ms. Babcock, Desiree, Martha. No one got back with us for a whole month. No one. The communication over there is, and I mean the communication over there.
Mr. Bailey, let's just stick with the facts. Your argument is not compelling and it's not cogent. So let's stick with what the facts are, sir. So, staff, what's the path forward? Mr. Bailey has said that he'll submit to a set of fingerprints.
You want me to respond?
Please.
Well, then in that case, if he submits to the fingerprints, we can move it forward.
Well, why wasn't this explained at the beginning?
Mr. Bailey, I'm not sure where the disconnect was, but this is clear. NRS 706-4463 2B as in boy. Again, I'll read that 706-4463 2B. Says that you have to submit a set of fingerprints. So we can do one of two things today. We can ask for a motion to deny this because we don't have a set of fingerprints, or I'll give us the opportunity to table this and you submit a set of fingerprints, and then staff can bring that back. What would you like us to do, sir?
I have a question. What's the purpose of a CPN license? What is the purpose? Because literally it took us 2 weeks to get a CA number. It took me less than 24 hours to get a DOT and MC number. What's the purpose of a CPCN license? So I can answer that question for you correctly.
Mr. Bailey, Administrative Attorney Yonit Wilburn, the state of Nevada has laws. They're in the regulations. It specifically says requirements for operators of tow cars. If you want to operate a tow car, you must get a CPCN with this.
Okay, so here's my second question. We won AAA, we won Progressive, we won insurance calls. The information I got from the state, from Reno when Howard was there, it states in there that we do not have to have a CPN license or an insurance call. Is that correct?
I'm not here to give you legal advice, but Ms. Babcock?
Is that correct?
That is the understanding. If you do the insurance tows, you're exempt from us.
Well, sir, we don't need a CPN license. We want a refund, at this point.
No, there's. Okay, have your attorney contact us. All right. Thank you, Mr. Bailey.
No problem. You guys have a good day.
Thank you. All right. Mr. Teddy, we have docket number 24-12017 for an application. What would we like to do with that?
My motion will be to deny item number 100, Chair.
I'll second that motion. Is there any other public comment on this?
Hand raised online.
Okay, All right, bring it back to the board. We have a motion by Teddy, second by Hartung. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. Okay. All right. That takes us now. I think we can get a couple more things done. And we'll try to break here. Let's before we go to lunch. Applications for certificates of public convenience and necessity to provide charter bus services, items 106 through 108. Ms. Babcock.
Yes, they are charter bus applications and you could take them in block.
Okay. All right. And I love this name, 9 Cans of Ravioli LLC. I only brought 8 today, commissioners, so I'm not sharing. I need a motion for 106 through 108.
Mr. Chairman, I make a motion, we approve docket items, agenda items 106 through 108 as noticed on the agenda.
Thank you.
I'll second that, Chair.
Second by Teddy, motion by Zoka. Is there any public comment on any of these items?
No hands are raised online.
Perfect. Seeing none, all those in favor, please signify by saying aye.
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 Motion carries unanimously. That takes us to application for fully regulated carriers, item 109. Docket number 24-11016. Ms. Babcock?
Yes, is the application of Reno Outdoors for a scenic tour service up in the Reno area. They've requested 3 vehicles, which they can financially support, but do not currently have the market for it. So they will be starting with 1 vehicle and then adding the other 2 as demand increases. And in order to do that, they will be showing staff that they are financially viable at that time.
Okay, perfect.
Staff certification.
Perfect. Is there anyone wishing to speak on item number 109?
No hands are raised online.
Seeing none, I'll bring it back to the board. Looking for a motion, commissioners.
Mr. Chairman, I move that we approve agenda item 109, docket number 24-11016 as noticed on the agenda.
I'll second that, Chair.
I have a motion by Zoka, second by Teddy for item number 109 as approval. All those in favor, please signify by saying aye.
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 Motion carries unanimously. Okay, let's keep pressing forward here. That takes us to item number 110, docket number 25-05031, the application for open top sightseeing in Las Vegas. Ms. Babcock, go ahead.
Yes, this was tabled from a prior general session and staff was okay with a lot of what they did, which they got interim approval on. And there was just this one where they're proposing some surge pricing type arrangements.
And dynamic pricing, yeah. And as I read this, commissioners, I'm kind of opposed to this. I don't, and while I understand the nature of this, the way that this is set up, and Ms. Rushton, I see that you've come up. I have questions. So go ahead, Ms. Rushton.
Thank you. For the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of Big Best Tours. Joining me today is the general manager, Mr. Jacob Wadeen. We'd first like to start by thanking staff for their consideration of the tariff and their approval and the commission's approval of the other items that were submitted as part of this tariff application. As noted by Ms. Babcock and yourself, Chair, the issue that's come up is specific to a rule. And the current authorized rule allows for certain reductions in the rate, the approved rate. And as you know, that's authorized under the statute based on the fact that they do tour and transportation. And so they can discount up to a certain amount. So there's no objections to that, and that's been previously approved. What's before the authority today is specifically identified in tour and transportation circles as dynamic pricing. And specifically what it means is that when a consumer goes on to buy a ticket, online, they receive notice of the fact that if they buy the ticket for the tour on this specific date, this is the price. If they buy it within 7 days of the actual tour, it's another price. And if they buy it the day of the tour, it's a third price. So it's 3 levels of pricing. The base rate would be akin to what you usually see, I would say, with respect to a TNC. So you have the approved rate. And then if an individual went to go book this 7 days in advance, because again, think about supply and demand, there's an ample degree of supply, they get a discount. Again, that's already authorized. But if they book it the day of, within hours of the tour actually taking place, the price goes up. It's clear what the price is. It's transparent to the consumer before they purchase this. And I would respectfully submit that the variation is most often within 10%. You're talking about a $1, difference or a 10% difference between the approved rate and the surge rate or the dynamic rate. And so again, this is one that is very common within the tour and transportation industry, and it's utilized by Big Bus Tours in their other tour operations, both nationally and internationally. It also takes into consideration the fact that, as you know, in the tourism industry, there is a long line or a long chain with respect to how referrals are made, the way that brokers work. And what we propose here, and we've got some handouts that Jacob will walk you through, is doing what I would say upfront pricing. And so when a consumer goes onto their website, they know exactly what it is, and they're not the other discounted fees or the broker fees or things that you see, I would say, on other websites. They're just not specific to a CPCN. And I think it's important to note that because, again, the legal standard, specifically by statute, when it comes to tariffs, is just and reasonable. And what that means, and I can tell you, if you look at the legislative history, that specifically goes to the fact is whether or not the rate is compensable or predatory. Is it one that is so otherwise low and off the scale and everything that it could not be compensable and the carrier could not meet the 20% equity by consistently charging it? Or is it predatory in the sense that it's adverse to other carriers and their rate structures? And we would respectfully submit that's not what happens here, that it does comport with the statutory intent because it's known to the customer ahead of time. It's on a website that's very transparent and the customer has a choice. They don't like the night tour and the price that it's set out with respect to Big Bus Tours. They can look at other carriers who do the same or similar type tours along the strip. So again, the factors that the commission and authority generally look at is one, is the rate fair and just? 2, does that mean that it's compensable and that it's otherwise not predatory? Are there other options within the industry? And is it within the range of those of the other industry carriers? And we would respectfully submit that it is. Those are the legal arguments. But I think what's also important is to hear from an operator's perspective, the pragmatic basis for doing this and how we, again, believe that it does not conflict with the statute and the regulatory standards specific to tariffs. And with your permission, Chairman, may I please turn it over to my client if it's time to offer further comment?
Yes, go ahead, Mr.
All right. For record, Jacob Woodine, Big Bus Tours.
Thank you.
You can see on the paperwork we sent over, the first one is just kind of the example of what some of the pricing may look like. And there's a few examples here, just the copies that I made, just some screenshots of just other companies as well as ourselves. The very first copy you'll see is just our calendar, that what it looks like on our website, or our street POS machines the drivers carry or team members carry. And it'll always show a calendar of availability and the cost of each day. And as you can see currently, it is at our normal tariff rate. That's what everybody sees. If you go to the second page, I put a competitor on here to show like other hop-on, hop-off carriers. Old Town Trolley is a national company around the U.S. and they're closed-top vehicles, but they're big like us. And you can see this one varies quite a bit with a base fare of $52.25. And then during certain days of the week goes up to 55 or 57. And then the day after Christmas, this shows jumping up to 61.25. So again, very clear, like they're not hiding anything. It's all very normal. Guests say, oh, I don't really want to travel that day, so I'll pick a cheaper day, and then they move on. And then I put on the third copy, something a little more like common for all of us. I'm assuming most of us have flown on Southwest Airlines. They're one of the most dramatic versions of it where, you know, a one-way as low as $55 and the same one-way as much as $185. So we're definitely not looking for these dramatic big movements, but I wanted to show that it's just a normal trend around the travel and tourism sector. And then the last sheet is partner we have in Chicago that our Chicago operation likes to try to model off of. And this is the 360 Chicago building, which is the John Hancock building. And theirs is also, they have a base rate, if you see on the top left, of 29, and it says from. This is a common terminology used throughout the tourism industry. And sometimes carriers can be a little shysty about it. They'll put from, and then that's 1 day, one time a month. And that's not the angle we're chasing, but they use that terminology of from. And then you can see, again, it ranges from 29 to 30 to 31 to 35, depending on the day and also depending on the time. At sunset, you know, your prices are going to be a little higher because the increased people that want to see a sunset from an observatory. Those are just some general examples, but what I really want to be clear about is we're definitely aiming for a common practice. We're not chasing something different or unique. Simply supply and demand. We're not about hidden fees. We don't charge platform fees. You're not going to hear arguments from our customers like you'd hear from a Ticketmaster complaint. I think we've demonstrated in the past regarding fees that we're allowed to charge, like we could pass through the passenger tax, and we don't. We're one of the few carriers that eat that for the guests, so they don't have this extra fee on their credit card or at the counter when they're trying to buy a ticket or when they go online. We don't chase any type of fuel surcharges. So again, just as just a note, it's not about trying to get extra money out of the guests just because we can. We are trying to stay current in the trends of general tourism and product and pricing strategies. And really, as Kimberly mentioned, these variances are not meant to be big shots from our $57 tariff rate on our traditional ticket to jump up to, say, $75 in the same day. These are meant to be from going from a discount up to retail, and then on the same day maybe jump $1, $2, even $3 on a really fun, exciting weekend, or on our night tour, which is probably the best example showing capacity base, because some of our night tours don't have capacity. We'll add a night tour, we'll add another bus, we'll add a fifth bus, but on some of our buses, we only have one departure nightly. So when it gets to the 70% full, we just want to get a few extra bucks here, a few extra bucks there, to truly just maximize the overall revenue for the business, because ultimately I answer to a New York office and they answer to a private equity firm, and we're trying to just be just a little better to show up when it comes to that end of the month reporting that said we did our best.
Okay. All right. All right.
I just love to hear what kind of questions you guys have, and I'm happy to adjust just to help like kind of happily meet in the middle.
Okay. All right. I'm going to bring it back to us. Ms. Babcock.
Yes, sir. I understand what they're trying to do. However, the issue we have is that tariffs are for the public to understand what they're being charged for whatever the service is, and discounts up to, or words that pricing can return. You still don't know. And I don't know what the answer is for them to be able to do what they're looking to do, but the up to 30% off, then what does that mean? And then close to the date within 7 days. So what is it on the 7th day, the 6th day? You know, it's just wide open, and I don't know how the public is then aware of what they're being charged.
Okay.
Nor also for enforcement.
May I answer that question?
Review that.
No, hold on, sir. Hold on, Mr. Whiting. Just give us a second here. So, okay, commissioners, Mr. Teddy or Mr. Zoka? Questions for staff?
Go ahead. Go ahead. I don't think I have it. Well, I guess for me, I'd like to hear, Mr. Chairman said at the outset that you were concerned about this. So maybe if I could hear your chairman's concerns, and then I can note mine as well.
I can.
Thank you.
Yeah, I can articulate them, you know, and Mr. Mr. Whiting opened, he said pricing may look like. It's not what it is going to look like, it's what it may look like. And I had some things written down here, but I'm uncomfortable. I'm uncomfortable with allowing a dynamic model with a discretionary 30% discount and a 10% upward adjustment. Would give the carrier a floating tariff, which blurs the line between regulated CPCN and a a regulated and unregulated market actor. So those are some of the things that I had put into place, and then I'm concerned that if we put this into place, I mean, we're going to see a whole line of carriers coming in wanting this dynamic flex pricing that I think just could be very difficult to track.
Chairman and members of the authority, if we can respond, what I'd like to do, if it's acceptable, is ask Jacob to respond to Ms. Babcock's question, because I think it's an important one, and we have been prepared to address this.
Well, I answered, hold on, I answered Mr. Zoka's question. You wanted to hear what I had to say, Mr. Zoka, because I want to give the board an opportunity to just ask staff questions also, and then I'm going to give him an opportunity to come back in. So Mr. Zoka, did I answer your question?
You did, Mr. Chairman. I do have a question for both staff and the applicant, if I might, Mr. Chairman. Would that be okay?
Yeah, no,
Okay.
that's exact. Yeah, I want that, and then I'll let the applicant jump back in and respond here. But I want to make sure that we're all kind of on the same wavelength as far as what staff's concerns are first.
So, Mr. Chairman, before I ask staff a question, let me just note where I'm coming at this. So, for me, when I look at the airline industry, they've been doing this for over 3 decades. When I look at the hotel industry, they've been doing it for at least 2 decades. And given the highly competitive environment that traditional operators now have to operate in between the TNCs and the autonomous vehicles and everything else that is out there for transportation, they have to have some sort of mechanism for sensitivity to what is going on in the market to be able to compete on an equal footing with other forms of transportation that are out there. So I'm certainly sympathetic generally to this principle of having some level of flexibility in the tariff. I think now on the other side of the ledger, what we have is, unfortunately, we have to deal with the statutes and regulations as they exist in a book and as we have to enforce them. So I think in some form, I would say this to the industry that they're going to have to go to the legislature and to the extent that this makes sense, propose this as a legislative change, or perhaps to the extent that some of this could be addressed by way of regulations, have it done via a regulatory change. For now, we have to deal with the statutes and regulations that are on the book. So with that being said, I think from an enforcement perspective, when we have somebody auditing their books from our enforcement staff, they have to be able to see why a customer was charged a specific rate on a certain date. I think that's very important. And I think it's also important that the customers understand what they're being charged and why they're being charged that number. So I think those larger principles all have a play here in terms of what we do here today. With that being said, I think my concern with the way it's currently proposed is that it just allows for too much flexibility to the operator. I would be more supportive of a somewhat scaled back version of this. Yeah, more of a solid metric in terms of, how this could be done. I don't think, this is just my personal opinion. I don't think this is the final answer, but perhaps we could tie it to capacity. We could have a top rate. And then, when capacity is a certain level, maybe a certain level of discount, but I see Ms. Babcock shaking her head. So, she has to deal with this from a different angle. But I think when there's a will, there's a way. I think there's a way to come up with something here that meets our responsibilities relative to the statutes and regulations. It also gives them greater competitive ability in terms of their rates. And so I'm looking to, so with that, putting all of that on the table, putting my heart on the table, now I want to turn it over to Ms. Babcock to see what potential solutions she sees in terms of addressing, coming up with something that perhaps scales this back, but at least give them some flexibility in terms of pricing. Thank you.
If
Okay.
I may,
So, yeah,
You would
go ahead. Go ahead, Ms. Babcock. Go ahead.
would have no way of knowing the capacity of a vehicle. But if there's a holiday and 5 days before the holiday, it's this rate, 4 days, it's that rate, 3 days, you can look at a calendar, but we can't tell capacity of a vehicle.
Correct.
Just one thought.
But I look at it though. If there was a maximum and the rate was charged, it's up to them to, me as enforcement, if I show up and I look, it's up to the carrier to show me and prove to me what the capacity was and why they charged that rate. Otherwise, they would be in violation, right? The onus is on you as you're adjusting those rates.
And I think to that point, members of that's where the calendar comes in, because the objective is that we would publish the calendar in advance. And so it would display the rates.
And I like that.
And then that way the consumer would know.
That is.
So
very
when they look at it and maybe, and again, as we talk about this, and I understand we're taking up your time, but I think this is really, staff and I want to work towards the objective of doing something. It's just, we need the input of the commissioners. But I think what we could do is bring this back and say, all right, we can agree that we'll publish, the calendar in advance so that consumers know. We'll agree that the discount will not be, it won't say up to, but we'll have a specific amount.
Yes.
And then we can agree that, on specific parameters such as the day of, this is what your calendar is going to reflect. And then you can, I guess, audit against it or verify that.
Yes.
So perhaps what we could do is, if it's not too cumbersome on the authority, and if staff doesn't mind, we could certainly work on that language consistent with what your comments have been, and then bring that back and again, work with staff. And if we come to an impasse, again, we're back here in front of you talking about some, why we think it will work or it won't work. But I think knowing what your thoughts are, that we can easily, we've got some direction now that we can go back to staff and work with them and get this through. I really do.
Well, all right. Mr. Whiting, go ahead.
For the record, Jacob Woodine, Big Bus Tours. So just to make sure I'm understanding correctly, the main concern is the flex up, because in the current tariff, we already have an up to 30% discount, correct? That the main concern is the flex upwards at an unknown time. Am I understanding that right? Okay. So you mentioned the it's on us to know. So on the night tours that we offer that are one bus only, thankfully we know every time there's no more than 66 seats on that entire bus. We only sell the top seats. We don't even sell the bottom. So we know exactly when the 70% mark hits, and then we'll be able to open our calendars up if we ever do get audited to say, so you can see at 6:52 on this day the rate changed because that was customer number 71%. So we will be able to easily audit that because of timestamps, customer journeys. They call them like click-through journeys. But that is easy to show if that part's ever needed. And those ones are probably a much easier, more palatable. The uptick version is the independent capacity night tours that only ever have that one bus. It's just easy to just go backwards and see the 70%, 80%, 90%. The ones that I could see would be a little bit more hassle, like our date on hop off service, where we just say, we would never in the same day have a team member say, hey, we're busy, let's charge $6 more. And we can clarify all of that. It will be on the calendar, like Kimberly mentioned, where let's say they scroll through to January and we know that it's a quiet time here, especially during the busier first 3 weeks during the convention season. they might see every Tuesday, Wednesday, and Thursday at a rate of like 20% less traditional retail. And in November, you would see nothing above because there's no part of January